Well, good morning, everyone, and welcome back to AJ111 Criminal Procedure. My name is Tony Farrar, and of course, I am your instructor for this semester. Today's lecture is going to be on Chapter 3, which will cover searches and seizure. And because there is quite a bit of content in this chapter, I may have to break it up into two smaller lectures, but I will do my best to try to stay within that 60-minute time frame, but we'll see how it goes. With that being said, let's go ahead and jump into the lecture for this morning. The first thing we want to do is we want to cover the learning objectives. What are we going to gain out of this chapter? What are we going to cover? Well, the first thing is we want to know about the Fourth Amendment protections, but we also need to understand some of the historical background of the Fourth Amendment. Next, we'd like to be able to understand the significance of a couple of different case laws. Those are those substantial landmark precedent cases from the U.S. Supreme Court. One in particular, the significance of the Katz versus United States case in development of the Fourth Amendment. And Katz is K-A-T-Z, not C-A-T-S. Anyway, number 3, explain why there is no constitutionally protected expectation of privacy in conversations with either an informant or an undercover officer, even when these are conducted in your home. Kind of an interesting thought, and we'll cover that. Number 4, identify the requirements for a plain view search. What is necessary to meet those requirements. Next, be able to explain the difference between curtilage and open fields and the factors to consider in determining whether an area is considered curtilage or an open field. And we'll learn a little bit more about that as we get through the lecture this morning. Number 6, know whether curtilage has an expectation of privacy from aerial surveillance. So if we have a fence and it goes around your house, and you'll learn this, that's considered part of the curtilage of the home where there is somewhat of an expectation of privacy. But what about over the top? What about aerial reconnaissance or surveillance? Is there an expectation of privacy in that situation? And we'll talk a little bit about that. Number 7, state why a lesser expectation of privacy attaches to, let's say public places and businesses and abandoned property versus, let's say, your home or your car. And then finally, the last one, number 8, be able to explain the difference between show of authority as it relates to seizures, physical seizures, and encounters. So that's kind of where we're going this morning. The first thing I'd like to do is start off by taking a look at the Fourth Amendment. So I'm going to read it to you. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches, not all searches, just unreasonable searches and seizures, shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Now, you'll notice one thing with the Fourth Amendment, it focuses on two parts. The top part deals with to be secure in your persons, houses, papers, effects, etc. But it also talks about there's a warrant requirement in there that not only does this apply to, say, searches of your vehicle or your car, or your person on the street outside of your residence, but if you need to get a search warrant, the same level applies, that probable cause level that we've learned a little bit about when it comes to what burden level. So everybody knows we need probable cause in order to search and arrest. So it's the same level of burden whether we search out in the field or whether we get a warrant for somebody's house. And we'll learn more about warrants as we move through the chapter. So I want to start with kind of a scenario. And then we'll move into the introduction portion. So on April 6, 1984, A police officer with the last name of Strackner asked the neighborhood trash collector to pick up the plastic garbage bags that the defendant, in this case Greenwood, had left on the curb in front of his house. And then after doing that, to turn the bags over to her without mixing up the contents with garbage from the other houses. And after the officer obtained this, the officer searched through the bags and was able to find items that were indicative of narcotic use. Based on that information, the officer then obtained a search warrant to Greenwood's residence based on the items that she had found. So hopefully you're following along. And in the house, the officer ended up finding a large quantity of cocaine and hashish, and the suspect Greenwood was arrested for felony narcotics charges. Now, the issue in this case that went up to the U.S. Supreme Court, in this case California versus Greenwood, was whether or not the Fourth Amendment prohibits the warrantless search and seizure, both, of garbage left for collection at a home. And that's part of this involves those words curtilage or open field or plain view, all these different phrases that we're going to learn. And we'll finish up the case at the end of our discussion on Chapter 3. If you want to know a little bit more, I have at the bottom, you can see there a link to the California versus Greenwood case, and you can look it up and find a little bit more information on that case directly if that interests you. Or you can go to, I believe it's page 70 in your textbook, because I know you've already read your textbook, right? I know you have. And you've already read the case California versus Greenwood, but it's on page 70. And again, it talks about, did the police or should the police require a warrant to search the trash? And that's part of all this Fourth Amendment stuff, and it fits right into our discussion on criminal law and criminal procedure. So with that being said, I want to talk a little bit about different types of evidence as we move into the introduction, and then we start talking a little bit about the history of the Fourth Amendment. So the investigation and prosecution of crime, it's going to require the collection of evidence of criminal activity. And this may encompass a couple of different things. It may be physical evidence or testimonial evidence. And you'll see that as we start to go through this, that typically evidence is generally categorized in one of four different areas. There's going to be testimonial, there's going to be documentary, there's going to be demonstrative, and then physical evidence. And I think it's important that before we move forward, that I give you just a little taste of each one. So let's briefly define those, or what falls into that area, since we know that investigations are going to require the searching and collecting and seizing of evidence. So first of all, testimonial evidence. Well, this is information that is gained through interviewing and interrogating individuals about what they saw, whether it's eyewitness evidence or what they heard, which could be hearsay evidence, or what they know, which might be character evidence. This all falls under the umbrella of testimonial evidence. And then we have documentary evidence. And this typically includes written materials, including emails and texts, and audio recordings, and even video. And then we have demonstrative evidence, and this includes things like mock-ups and scale models of objects or places, like the crime scene. And what this does, these mock-ups help juries visualize more clearly what they are unable to personally view. Not all juries go out to the scene of a crime and look at the actual crime scene. It doesn't happen very often. So the prosecutor will make these mock-ups or do these crime scenes. That's why you do a crime scene sketch as an investigator. That's why you take a bunch of pictures as an investigator. That's why they have these cool 3D scanners where you can set it up in one corner of the room and it will basically put together a scale model or diagram, and this helps, again, the juries visualize more clearly what they are unable to personally view. Then finally we have the last one, which is the most common type of evidence that investigators will deal with, and that is physical evidence. And physical evidence is anything real, meaning it has substance that helps establish the facts of a case, and it can be seen, it can be touched, it can be smelled, or it could even be tasted. So in this case, it could be a firearm, or it could be some shell casings. A couple of other examples, again, it could be blood or a firearm. It could be blood spatter. Okay, it's not splatter, it's spatter. And it might be able to show the direction in which a victim or a suspect was either leaving the scene or what have you. Could be rope that was used to bind a victim. It could be tire tracks or even a shotgun shell. And all of these are different types of evidence. Now, again, a criminal investigation may prove relatively uncomplicated. Eyewitnesses may be able to identify the suspect, and investigators might even find forensic evidence at the crime scene, some of the physical evidence we just talked about. Or a suspect may even decide to turn themselves into the police. But in most cases, this type of evidence is unavailable. And some of the reasons could be that eyewitnesses may be reluctant to come forward to talk, or the forensic evidence may point to a number of yet to be identified individuals, or suspects may just disappear or refuse to cooperate with the police. And in these situations, the police then typically turn to other methods of collecting evidence. And part of that comes back to the searching and seizing. So again, when you look at the crime scene, a typical investigation may prove relatively uncomplicated, or it could look like these two pictures, where you might have a crime scene like the one in the bathtub where somebody's wrapped up in large trash bags and then duct taped, and this is where they were actually killed at, kind of like a hit. Or on the right, where the crime scene just has so much evidence, and you can look at the number of placards that are laid out there. So things can be very, very complicated. And if you need a closer look, think about this as a crime scene. And that's all you have. You're not going to have any, maybe not that much physical evidence per se. You may not have a suspect that turns themselves in. You don't have any witnesses per se. So you're going to have to look at other means, other ways to do things, other ways to search and seize and gather evidence. So again, eyewitnesses may identify themselves and make it simple, but most cases this type of evidence is not really there. So when this occurs, we have to turn to other methods of collecting evidence, and it could be fingerprinting, it could be what we're going to kind of cover here in just the next second. So with all that being said, let's talk about some of the other ways, the other methods of collecting evidence. And these include things like search and seizure, which means that the police may search and seize evidence from people, from cars, from homes, and from other locations. And as long as law enforcement complies with the Fourth Amendment, everything will be okay, and typically that evidence will end up being admissible. And this, again, falls under the Fourth Amendment, the search and seizure. The next would be interrogations. The Fifth and Sixth Amendment permit the police to question suspects, and we'll talk about that a little bit more when we get into Chapter 9. But again, this is a different thing. We're going to have to go out and interrogate people and interview eyewitnesses, and how do we get those statements, and are we doing it within the confines of the law? And then finally, identifications. Eyewitnesses and victims may be asked to identify suspects from, let's say, lineups or field show-ups or even photo lineups, employing procedures that meet the requirement of the Fifth and Sixth Amendments. And we'll talk about that a little bit in Chapter 10. So you can see how the Fourth Amendment really comes into play as it relates to criminal procedure. So, as we begin our discussion more deeply on the Fourth Amendment, search and seizure, we need to understand that the primary purpose of searches and seizures, again, is to collect evidence that will assist law enforcement in the investigation of unlawful activity. And these searches and seizures may involve, again, various types of evidence. And let's talk about a few. And if you haven't noticed my cool ice cubes, these are pretty cool. So yeah, I thought I'd share that with you. Anyway, let me get back to the lecture. It may include what we call instrumentalities of the crime, and these are items that are used to carry out the crime, maybe a firearm or a knife or what have you. Then we have fruits of the crime. This is typically what's taken, what is gained. So things like money that's stolen from a bank or jewelry taken from a home or a wallet taken during a robbery or computers that are stolen from a store. So those are the first two. Then we have contraband. This might be unlawful drugs and other prohibited substances. Evidence of criminal activity. This could be things like clothing with gunpowder stains or residue, bloody clothes, or even DNA that links a suspect to a crime. Again, this is various types of evidence as it relates to search and seizure. And then finally, we have incriminating statements. These could be statements that are overheard, let's say, during an electronic surveillance. So we need to understand, again, the primary purpose of search and seizure is to collect evidence that's going to assist law enforcement in the investigation, and it involves various types of evidence. So with that being said, the Fourth Amendment is, again, directed at searches by the government and does not restrict searches and seizure by private persons. Now, the amendment protects individuals against unreasonable search and seizure in 4 different protected areas. Okay, and remember the fourth. We talked about the Fourth Amendment, about the right of the people to be secure in their persons. Remember, houses, papers, and effects. So we're talking about those 4 areas. So persons would be, this protects individuals against unreasonable detentions and unreasonable searches of their persons. For houses, homes encompass all types of residences, dwellings attached to the residence, and areas immediately surrounding the home, as well as commercial businesses that are not open to the public. Papers, this would include things like letters or diaries or business records or bank statements. And then effects, that would include things like personal possessions like automobiles or clothing or firearms or even computers. So again, the amendment protects individuals against unreasonable search and seizure in these 4 different areas. So the Fourth Amendment tells the police that they may search for and seize evidence of unlawful activity as long as the searches and seizures follow the mandates or the dictates, if you will, of the Fourth Amendment. And as we're going to look at in the next couple of chapters, we will see that the U.S. Supreme Court has basically devoted a lot of effort into looking at the Fourth Amendment and some of the issues surrounding search and seizure. So again, the U.S. Supreme Court has devoted well over 100 cases and thousands of pages to interpreting the requirements of the 53 words that encompass or compose the Fourth Amendment. In undertaking this particular task, the U.S. Supreme Court has struggled to balance the social interest in conducting searches and seizures to investigate unlawful activity, because that's what law enforcement does, right? Against the interest of persons being free from governmental interference. So remember, I showed you this picture back, I believe, in chapter 1, and it has Lady Justice, and we know why there's the blindfold on, but we talk about the scales of justice, again, being able to balance those two things. So, you know, that struggle of balance in allowing law enforcement to do their job, to conduct searches and seize property and to investigate unlawful activity against the interest of individuals being free from governmental interference in their personal lives. So again, it's a very, very tough balance. Now, there are three basic steps in analyzing a Fourth Amendment search or seizure that we're going to be talking about in this chapter and even in a couple other parts of the textbook. The first is exclusion from evidence. The second is the definition. And the third is reasonableness. And I'll expound on those just a little bit more. So, exclusion from evidence. If the search or seizure was unreasonable, does the exclusionary rule require that the object or objects seized be excluded from evidence? Or may the item be introduced at trial? And we'll talk more about the exclusionary rule further down the road in chapter 10. But again, these are steps in analyzing the Fourth Amendment search or seizure, okay? Definition: did the government engage in a search or seizure as defined in the Fourth Amendment? And then finally, reasonableness. Was the search or seizure considered to be reasonable? That is, was it lawfully conducted? And we'll talk a little bit more about that in chapters 4 through 7. So, in this chapter, we're going to define and discuss the Fourth Amendment search and seizure of individuals. And I'm going to ask you the question, why do we believe it's important? Why is it important for us to consider search and seizure of individuals? And I'll kind of let you think about that as we start to move forward. One of the reasons is because as technology advances, the Supreme Court undoubtedly is going to be asked to determine whether various types of intrusions constitute Fourth Amendment search and seizures that require police to obtain a warrant based on probable cause or not. So they're going to have to figure that out. So, you know, your cell phone, can law enforcement just stop you? Even if they have a reason to stop you, can they just like search your pockets? Can they just search your cell phone? Can they search something in your house without a warrant? And as technology advances, we're going to have to, you know, the Supreme Court actually is going to have to determine whether, at what level these intrusions are at. Hopefully that kind of all makes sense. Because again, at the end of the day, we're looking for the balance. To balance the need for police to investigate crime against the protection of individual interest and privacy. So, when we look at different things, and these have all come out in some cases. Drones now, they're becoming more popular. Even law enforcement uses drones. And we talked a little bit about the possibility of aerial surveillance. Can we fly over someone's house and take pictures? Does that constitute an unreasonable search? DNA, when someone is arrested, is it okay to swab somebody's cheek, their inner cheek, for DNA and place that DNA in a database? Cell phones, is it lawful for law enforcement to look in your cell phone without a search warrant? The same thing with computers. Or can we track your cell phone or track your computer? So again, these are things that the U.S. Supreme Court is going to have to deal with as technology continues to develop. So now let's look at a little bit of history before we start jumping into some of these particular search types and their affiliated cases. So the Fourth Amendment was included in the Bill of Rights to protect individuals against the far-reaching searches and seizures that were conducted by British authorities in the American colonies. And remember, we talked a little bit about that in Chapter 1. A particular source of anger was the use of what they called general warrants and writs of assistance to search homes and businesses. And a general warrant, by definition, was issued by a judge at that time, and it authorized searches anywhere at any time for anything for kind of any reason. So you can probably see the reason that people were a little bit upset, because they didn't really need a reason. They could search for anything, like a fishing expedition. They could just come into your house with that general warrant and just look for stuff. So hopefully that makes sense. Now, things have of course changed, but this is a little bit of historical background. Now, writs of assistance were a form of general warrant that authorized an official of the English Crown to compel a police officer and citizens to assist in the search. Now, a number of colonial states responded by basically prohibiting general warrants, and the Virginia Declaration of Rights in 1776 proclaimed that general warrants were basically not good, not fair, oppressive, illegal, and basically void. But you can see the issues that come about when we talk about some of these historical things. Now, kind of fast forwarding a little bit today, the U.S. Supreme Court, while expressing a preference that searches be conducted based on a warrant founded on probable cause, they've also recognized that it is reasonable in various instances for the police to conduct a search and make a seizure without a warrant. I mean, just imagine in today's law enforcement if you needed a warrant to search and arrest always, because things happen so fast and you don't always have time to get a hold of the on-call judge and get a warrant signed. How would you do that? Then you would have to detain someone for a longer period of time. So you can see how things have changed. And although the court would prefer a warrant, because the warrant is going to be reviewed by a judge that's a non-involved third party, they understand that there is a reasonableness factor built in here, where there are times where you don't have time to get a warrant in order to conduct a search or make a seizure. And these include what we call special need searches. And these are intended for protecting the public rather than collecting evidence, because sometimes, again, we know that things really happen. And these searches do not greatly intrude on an individual's privacy while they protect the public safety. And they could include searches, let's say, at airports or at the border between the United States and Mexico, or the United States and Canada. And we'll talk more about these in chapter 7, but there are some exceptions to the warrant requirement. And now you've seen that when you go to the airport, you go through all the detectors and things like that. If you're going across the border, you're going to be subjected to all these different detectors and things like that. Even at certain checkpoints, if there's, say, a mass casualty event or an active shooter, things like that, there are some public safety issues that allow for, again, warrantless searches and, in fact, warrantless arrests. And we'll talk a little bit more about that later on. So what about our expectation of privacy, though, as we start to focus in on searches first? Well, in a crucial case, Boyd versus United States, the U.S. Supreme Court adopted what they call a property rights or trespassery approach to the Fourth Amendment. And the property rights theory protected individuals against physical intrusions or trespass against their persons, houses, papers, and effects. And physical intrusions would be actual physical entry into a location or examination of papers, etc. And the scope, again, of the protection would be persons, houses, papers, and effects. In another famous case, the case of Olmstead versus United States, this case presents the limitations of the property rights approach. And here, in this case, Olmstead was convicted of conspiracy to unlawfully import, possess, and sell liquor. And the central evidence that was relied upon at trial was gathered through warrantless wiretaps of this individual's office and their home phone. And I have a link at the bottom there if you want to know a little bit more about the particular case itself. Now, the U.S. Supreme Court in this particular case, in a 5-4 vote, and when you see the votes of the U.S. Supreme Court, a lot of times there is a divided court. They basically rejected Olmstead's contention that the close to 800 pages of notes gathered from the wiretaps had been obtained in violation of the Fourth Amendment. The majority decision basically rested on two conclusions. First, the conversations that were heard by federal agents were transmitted across telephone wires that did not involve the search and seizure of a physical object. And then second, the wiretaps that they used were attached to the phone lines outside of the home and did not involve a physical intrusion into the home. And here, again, this is interesting. The Supreme Court reasoned that the language of the Fourth Amendment cannot be extended or expanded to include the telephone wires reaching to the whole world from the defendant's home or office. And the intervening wires are not part of his house or office any more than are the highways along the roads in which they are restricted. So again, there were some that didn't agree with this, but that was a pretty famous case that talked about, intrusion. And again, we talk about that physical intrusion. Another famous case, which we're going to talk about, would be in 1967. This is the Katz versus United States case. Now, in 1967, in Katz versus United States, the U.S. Supreme Court adopted Justice Bandery's viewpoint and overturned or overruled Olmstead. Now, in the Katz case, the U.S. Supreme Court rejected that trespassery approach and came up with a new one. They adopted what is known as the expectation of privacy test for the application of the Fourth Amendment. So I know it sounds confusing, but I'm going to back up. So Olmsted, in this case, they didn't physically intrude, okay, which was the trespassery approach, right? They didn't look at the right to privacy approach. They stuck with the trespassery approach. And because they didn't enter, this court at that time thought, well, you know what, it's okay. The wiretap was all right because they didn't physically intrude. Well, later on, they took another look at this case because this cat's case was brought to the Supreme Court, and the viewpoint of the court changed. So instead of the physical trespassing approach, they adopted the expectation of privacy approach. That is now the test for the application of the Fourth Amendment. And I think that kind of helped a little bit, right? So if you want to know a little bit more about the Katz versus United States case, I also have a link down there, and you can take a look at that. Now, Justice Louis Banderas, dissenting, basically said every unjustifiable intrusion upon the privacy of an individual by whatever means employed must be deemed a violation of the Fourth Amendment. And they basically came up with, again, they formulated the expectation of privacy test. So, and in this test, there are basically two prongs. There's two parts to the test. There's the subjective aspect and the objective aspect. The subjective aspect is an individual exhibits a personal expectation of privacy. The objective portion is that society recognizes this expectation as reasonable. So let me give you an example. What about a phone booth? And some of you are millennials and you know, Generation Z and all that stuff like that, but a phone booth, you remember what it was, with the doors on it. Would there be an expectation of privacy in a phone booth? How about a different scenario? What if you were eating at a restaurant and you were talking about committing criminal activity and someone in the booth next to you heard that? So this is where the two-part test kind of comes into play. And Justice John Marshall Harlan, in his concurring opinion in the Katz case, again, helped establish this two-part test for a Fourth Amendment expectation of privacy. And it's been followed by the Supreme Court ever since. And a little more on the Katz case you can find on page 53 in your textbook. So when you look at a legal equation to kind of help you formulate this, so your expectation of privacy, again, exhibit an actual subjective expectation of privacy, plus the expectation is one that society is prepared to recognize as reasonable. And then underneath that, the expectation unreasonable would be what persons knowingly expose to the public, even their own home or office. Okay? What they seek to preserve as private, even in an area accessible to the public, may be constitutionally protected and it may not be. Okay, but you're going to add this information. Information turned over to a third party is kind of an assumption of risk. And we're going to talk about that in just a second. I'll kind of clear that up if it's a little bit gray. So let me kind of go back to the search and seizure thing for just a minute when we talked about looking at, you know, what you might be able to search for and some limitations. So let's say that you have written a search warrant, and the search warrant is going to be for something larger than, let's say, this basket. So maybe a big boom box or something like that. So you're looking for a bunch of stolen boom boxes or whatever. So when you're searching and your search warrant, you can search throughout the whole house for this, but okay, if it's a place that won't really house the boom box because it won't fit, there's a question as to whether or not you would be able to search. What about a 55-inch screen colored TV that's been stolen and that's what you're looking for? Can you look in the washer and the dryer? Okay. Now, if it's a smaller item, then of course you will be able to search in more places because the item is typically smaller. The same thing with you if you arrest somebody in their house. This is why we have procedures, and you're going to learn a certain case in a couple of chapters. We're going to talk about Shamel, which basically gives officers the right to search. If they make an arrest, they can search the person or the area that a person might have immediate access to. So let's say the couch that they were sitting on, or the table, or the little desk drawers right here. Because when you go in the house, somebody could hide a weapon or they could gain access to something really quick. But that doesn't mean you can search the entire house. And we'll talk a little bit more. You can do protective sweeps, but that doesn't mean you can start searching everywhere. But you can look for suspects, but that's it. But we're going to learn a little bit more about all of that as we go through the rest of the information. So a little bit more on informants and eavesdropping to kind of clear it up. In the Katz case, the government electronically monitored a conversation without consent of either of the participants. Okay? The Supreme Court recognized that Katz had a subjective as well as reasonable expectation of privacy in the content of his phone calls, and held that reasonable under the Fourth Amendment required a warrant. It'd be the same scenario if I asked you about the phone booth. The reason they have this booth in the door is because there's an expectation of privacy, okay, that people won't be able to hear what you say. So that would fall under the expectation of privacy. A couple of other things. So what about some other scenarios? And then we'll move on, talking more again about informants and eavesdropping. So in this first scenario, let's say that a suspect talks to an individual without knowledge that he or she is an undercover officer or an informant. And then after they talk, the information that the officer or the informant gleans is going to be taken back to police. Is that, or do you think that is, a violation of unreasonable search and seizure? What do you think? Well, how about a second scenario? And we'll answer these. In a second type of scenario, the agent or informant is wired up this time, which means they have an electronic device. And they go into somebody's location, let's say it's their house, and the conversation is recorded and it's live, it's directly transmitted to the police through a remote location. What are your thoughts on that one? So a couple of interesting scenarios, okay? In these two scenarios, the Supreme Court has kind of taken a different approach to what we call the false friend cases, in which a suspect might talk to somebody without knowledge that he or she is an undercover officer or an informant. In these cases, the Supreme Court has held in both situations that the suspect has absolutely no reasonable expectation of privacy because he or she assumes the risk that the conversation may not remain confidential and could be communicated to the police. Now, it would be different if that person was in their house on the phone and the officers illegally put a listening device in there without a warrant. Does that make sense? But if you're talking to someone face to face and you're talking about criminal activity or what have you, and whether they're going to take that info back or whether they're recording you or whatever, there's no expectation of privacy because the court assumes under the false friend act that we're talking about that you are assuming the risk that the person that you're talking to is okay and that the conversation, it might not remain confidential. So it's the gamble that you're going to take. So hopefully that kind of makes sense a little bit. And there were also a couple of other very, very interesting cases as it relates to informants and eavesdropping. One of them would be the Hoffa versus United States case, which basically talks about misplaced confidence that the information would not be released. And the United States versus White case, again, that talks about direct statements or electronic devices as the same under that risk, meaning that you are basically going to assume the risk. So a little bit more if you're interested, and then we'll probably break this into two different lectures. In the Hoffa versus U.S. case, Edward Parton, a local Teamsters union official and government informant, visited the hotel room of Teamsters National President Jimmy Hoffa. You've all heard that name before, who was standing trial for union-related corruption. And Parton reportedly overheard conversations in which Hoffa conspired to bribe jurors. Parton later testified as the government's central witness at Hoffa's prosecution for jury tampering, and the Supreme Court held that although the hotel room was a constitutionally protected area, Hoffa was not relying on the security of the hotel room. He was relying upon his misplaced confidence that Parton would not reveal his wrongdoing. And nothing, basically, in the Fourth Amendment protects a wrongdoer's misplaced belief that a person whom he voluntarily confides his wrongdoing to will not later reveal it. And you know, it kind of makes sense, right? Well, would it make a difference that an informant was wired with an electronic device that recorded the conversation? Well, remember, in that United States versus White case, the informant was wired with a radio transmitter that relayed the conversation to government agents. And the Supreme Court, in this case, continued to follow that risk analysis type situation and held that if the conduct and revelations of an agent operating without electronic equipment do not invade the defendant's constitutionality, justifiable expectations of privacy, neither then does a simultaneous recording of the same conversation. So you can see, you know, it's kind of an interesting thing, the whole deal there. All right, so we're going to end this here, and we're going to break it into two different lectures, a part 1 and part 2. Just remember, informants and eavesdropping, there is an assumption of risk, and that I say we, but that individual, whoever that person is, assumes the risk that conversations may not remain confidential. And when we come back for part 2, we will talk about plain view. So stand by for part 2.